And again, it's like they were saying yesterday about how people always used to talk about security at these conferences, and they don't so much now because people kind of know that people are aware of it. People used to say, well, it's the cloud, it kind of goes on in the cloud, jurisdiction isn't really an issue. And I think in the internet, when the internet started, people used to say that was the internet, it's common, it's out there, it's creative, it's not hidebound by laws, and absolutely not. Just the definitive case was the Yahoo Nazi memorabilia case back in 2001, when definitively, if you're selling Nazi memorabilia in a country where selling things with swastikas on is legal, doesn't matter if you're selling it to the world. If you're selling it in, and that's why I pick on France as an example, because the leading case comes from France, not for any other reason, is the national law will apply to you. So you need to be aware of that when you're doing business. And then fundamentally, this means, as always, e-business is business, cloud computing is business. It's the old things that you used to worry about, you still need to worry about. How you deal with them in the cloud can be more creative and more interesting. And I think as vendors and consumers, there is a move to use lawyers less and take more of a view and accept contractual terms that are perhaps tougher than you might accept if it was an old-fashioned, you're buying a load of IT to sit in your building and be run by your guys, because people realize that the nature of cloud computing is to leverage all the cost advantages, etc. You kind of have to take more of a pragmatic view on contractual risk. So, looking from the vendor point of view, what we've seen is the bigger vendors are using quite smart technology to identify who their customer is and where their customer is based, and then using systems to send out appropriate terms for that country or for that consumer group, sort of this geolocation stuff. And Microsoft and Google both do that, and more people are doing that. And just sort of for the record, local laws around consumer protection, privacy, filtering, censorship, of course, if you're doing business in countries where censorship's applicable, the one-size-fits-all cloud solution might not work for you. And then, of course, tax, lest we forget, varies from jurisdiction to jurisdiction. So just a quick look at what's going on in the market. This is from the end of 2010. One of my colleagues is also a professor at Queen Mary, and his team did an analysis of 31 different cloud vendors' terms to see which laws were most common. And as you can see, surprise, surprise, the United States comes top with just under half of the contracts being under Californian law or Massachusetts law, etc. Then English law. And English law, it's interesting, sometimes it's because the vendor was English, and also Scottish law, because the vendor was Scottish. But some of these US vendors have started doing English law for customers in Europe, because they figure they can't write contracts for 27 countries all around the European Union, but they can at least translate an American contract into English law, because that will hopefully be more acceptable to European customers. And then other EU jurisdictions. Apple uses Irish law because they have operations there, and some Microsoft services and some Amazon services use Luxembourg law because they're based in Luxembourg. I'm not quite familiar with how good Luxembourg judges are at interpreting technology contracts, but it will be interesting if that ever does happen. But what's also interesting is some of them don't even specify it. And I think that can be a problem, because it leaves you uncertain as to what applies, and I'll come on to look at that in a minute. But sort of final thing is you keep reading, particularly Google, saying about how they're going to put data centers on ships because it will be greener, because you can use the sea to cool down the data center, etc. And that may well happen, but when that happens, you'll not only have all the jurisdictional issues of all the different countries, whether or not the customer is, etc., but you also get involved in maritime law. Now, I don't propose to go there, but think about it. So, some practical thoughts on jurisdiction, based on looking at this stuff from big vendors and how they're doing it, and also looking at what's going on the ground, in particular the people who forget to write down a jurisdiction in their contract. My view is, just as for anything else you ever do, think about the legal and regulatory constraints you face and make sure you can address them, whether by taking a business decision in an informed way or by addressing them in your contract. Work within it. Commonly, an off-the-shelf cloud solution, if you're going for something really driven by cost, it will commonly have a US state's laws applying, but it may have local laws. But your ability to negotiate is really, really limited. So you really need to think about, as a business, can you take the risk of all your data being in the US and a US contract applying with limited rights of redress and US regulators and the Patriot Act, etc., applying, and how do you feel about that as a European business? And how does that work if you have to comply with local laws in Europe, like data protection? How does that work with the business model you're adopting? And do please always specify a jurisdiction. If it isn't clear, and this is the high-level view, there are case law and treaties on this that we could go on about for hours, but I wouldn't. I'd get someone who's a litigator to do it. But if it doesn't specify in your contract, it will be the defendant's home jurisdiction, which could be anywhere, because who's suing who. But it could also be the jurisdiction where the obligation should have been performed to the data center on a ship point. That could be in international waters. Who knows? So you need to be careful about that. In the consumer context, it's likely to be the consumer's home jurisdiction. So again, that could expose you to lawsuits in 27 countries in the EU, for example. Very messy if you don't do it right. So, before I sort of move on to a more general look at what's going on in our experience in terms of contracting in the cloud, does anyone sort of have any jurisdictional thoughts per se? Because talking to Hannah beforehand, stuff had come back saying people wanted a talk about jurisdiction, a talk about contracting in the cloud, but there wasn't much detail beyond that. So if there's anything...
Yes, I've got one question. I'm involved slightly in cross-border matters of jurisdiction. And I think for aircraft flying from one country to another and railways going from one country to another, there's something called Unidroit.
Yep.
Does that also cover ships when they're international waters?
As I say, I'm not a maritime lawyer. There are similar principles would apply in international waters, but I think the point is ships in international waters are just a ship in international waters carrying stuff. Yeah. If that ship's processing data which is being accessed from all over the world and used from all over the world, what you need to do is make sure you're not relying on some treaty that was written covering shipping ingots or grain or something around the world. You want to set out quite clearly what should apply. But yeah, exactly. But if you have to fall back on all those principles, be it treaties or be it things like the Unidroit principles, fine, that's what you have to do. But what you don't want to be doing is paying my litigation colleagues to be analysing that for you and fighting over that. What you want to do is go, right, that's the issue. Now let's sort it out in a business sense, because that's what IT is about, that's what cloud computing is about, etc. It's about not having to go back to first principles and fight over arcane stuff. But I absolutely agree with you I think it's impossible for a treaty to be written on this, because the difference of opinion between the more police states that use IT stuff and the big, powerful countries like the US, which are number one in the market, and then the new emerging countries that want to be number one in the market, will just be very difficult to do.
Data perspective, you've got data, say, the example you've asked, stored on a ship somewhere, and you've got a customer using it, say in the UK. So I can understand the jurisdiction for the data storage and the person who's using it, but my understanding of how the internet works and such is that when you access the data, it actually can fly all around the world. You pick it up from one place and it can go to a server over in Russia, in Moscow, then up to here. And so that data's moving, that could be intercepted at any point.
I mean, there's two things. It could be intercepted at any point, or so would it be?
In Moscow, on a server in Moscow, because somebody there was actually collecting it all. What would happen there?
Take it step by step. If you're the consumer and your data's been exported outside the EU, and the contract you had with the business that you had a contract with didn't allow that to happen, there's a breach there. The culpable party is the person you had a contract with. So take your example, you're a consumer, you've got a contract with Facebook, and Facebook lets it go off to Moscow and you didn't have permission. Now, of course, Facebook has all the permissions in the world in its contract, so it can do what it likes, and you wouldn't use Facebook as an example. You would have a problem with Facebook, Facebook would have a problem with you. That would be that. Facebook would have a separate issue with its supplier who'd allowed that to happen. So you'd have a chain of complaints and issues. The thing is, if someone hacked it in Moscow, that's a kind of different situation. But if someone was accessing it in Moscow, you'd expect the contract to permit that to happen, for it to happen in a secure, compliant way. And if that happened, it would be fine. If someone hacked it, you've got a whole different situation. But from the consumer's point of view, their claim would be under English law against Facebook for breaching the privacy terms in their contract with Facebook. So that's kind of easy from the consumer's point of view. From Facebook's point of view, yeah, they'd have to look at the whole contractual nexus, which they were working in. Now, as I say, Facebook, huge, well-advised company. What the more interesting thing is the smaller startup vendor that doesn't really think about that and just clicks on, to the point the chap was saying about starting a company for £1,000. You just sign up to a bunch of web services without really thinking about it. Now, the likelihood is if you sign up to the chaps who are on the panel before, I'm sure all of them will have perfectly solid terms and you could rely on them and be certain that they wouldn't allow that to happen. But there's danger with the smaller people going with the smaller vendors who perhaps don't worry about this, take a view, get on with doing business, that you could find breaches, etc. And that's, at that point, then you'd be trying to follow the chain of liability and the chain of jurisdiction and trying to figure out what went wrong. So it's not particularly hard to do it right, and you don't need to hire very expensive lawyers to do it right. You just need to worry about it a little bit. Is that sort of...
Yeah.
Okay, so what's going on with contracts? Talk about jurisdiction, and you get to the contract. What's going on, I think, to the points we've just been discussing, people aren't really negotiating contracts, not like you do in the sort of traditional outsourcing or IT services mold. The point of cloud is it's off the shelf. You're not meant to negotiate it. What you're doing is you're paying a lower price for a standard service. Just like if you buy electric motors from a factory in China, you buy them, you expect them to work, and you pay the price that they are, and you check and find the cheapest one because they're all going to work pretty much. That's kind of how it works. Many service providers, and this is something we've actually analysed, and my colleague who's been doing this Queen Mary project's analysed. You know, many, if not most, service providers use non-negotiable terms, what are called click-wrap terms in the jargon. Like you used to get. Most people in this room look old enough to have bought software where it came in a cellophane wrapper and you took the wrapper off and there was legal terms in there that said you're now bound by these legal terms because you've unwrapped them. That's called shrink-wrap terms. You didn't sign anything, you didn't negotiate, you were just bound into it. And that's the sort of approach that Ryanair take. If you buy a ticket on Ryanair, you either accept the terms or you don't. You can't negotiate. Well, that's what a lot of these guys have adopted. And because they're working B2B, they can actually have quite a wide remit to impose terms they want. So they give themselves minimal liability for service failure. The recent Amazon outage on its EC2 West Virginia data center, which took out a number of websites, I'm reliably informed that it was all because the websites that went down weren't architected properly, and if you'd architected your website properly, it wouldn't have taken you down. But it did take some people down. And as I understand it, the most they could do is get a day's fees back, and a day's fees to run a bit of a data center in Virginia are minuscule compared to your whole business not existing for 2 days. That's it, that was your absolute thing. And what Amazon did is they offered 10 days fees back, even though they're only out for 2, because they're a customer-focused business, and that's what they did, because they offered 5 times as much as they had to offer. Now, I'm not sure, because obviously it's all a bit shrouded, but that's what they announced that happens. Who knows what other deals have been done, but the point is, they said, here you go, it's really cheap, architect it right, it's almost impossible that it fails, architect it wrong, it's your choice. Even cheaper if you architect it wrong, if it goes down, okay, you're off for a couple of days. Whether you're out of business depends. It sounds like everyone's got up and running and they're all okay, but it is quite an interesting story to follow. For people who work in regulated sectors, some other things that these contracts allow is that the vendor can subcontract at will, which means you do a deal with someone and then they do a deal behind the scenes that you know nothing about. They can do what they like. Again, that's the nature of cloud. They go to the most efficient place, the most efficient data center, wherever it may be in the world. Well, that may be fine because you get a cheap service as long as it works. But if you're in a regulated business, or if you have consumer data that is being accessed all over the world, you need to know that it's being done right. And so what's happening is is vendors are adjusting their terms to say, we won't send your data to other countries unless it complies with all these rules. Okay, tick that box. But if you're a bank or an insurance company, you actually have to know what's going on to your key contracts. So if you send something key out to the cloud and you do it on this basis, you would be breaching your regulatory requirements to have knowledge of who is handling your data, who is handling your key services. So third one is vendor can change or terminate the service at will. Now again, Microsoft Azure isn't going to be shut down. You know, IBM aren't going to exit the scene completely, but some of the smaller vendors may. They may just say, actually, that's it, we're shutting up shop. You've got a week to download your data and take it somewhere else. How do you do that? And then the final thing is they're very, very, very low on exit, which means at the end of the term, what happens? If you decide to move off, what rights do you have? Often you have no rights or very minimal rights. And again, the good vendors are realizing this is a sales opportunity and saying, right, on exit, we'll give you a nice data file, hand it over, everything's clean. But a lot of them, they offer nothing, or they charge you a fortune for doing anything. And so this is sort of what's going on at the moment. And people aren't negotiating it, whereas in traditional mold, you would negotiate it. You'd read it and go, that's unacceptable, how dare you? But because it's cloud, you're not doing that. So no legal talk is ever complete without Latin. So caveat emptor is the adage that applies, which is of course buyer beware. Read your contract, have a think, see how it works with what you're doing. But it's not just buyer beware, because as we were looking at in the jurisdiction point, because of the impact of local laws, the sellers need to be a bit careful here. What happened with the shrink wrap terms back in the 90s is likely to happen with these click wrap terms. So currently it's Californian law, take it or leave it. What happened in the 90s was the vendors, like Dell, etc., gradually realized actually they went from one page that was subject to Californian law to a booklet saying if you're in Romania, this applies. If you're in Singapore, this applies. And that's probably where we're going to get to in terms of the click wrap model. So sellers will address their exposure to suddenly finding themselves contracting under Californian law and that being illegal, and therefore they have no protection at all. And so you'll see differences around stuff emerging, which is in favour of the big vendors because it's easier for them. They've got the scale to afford to do that. For the smaller vendors, it's harder. But for consumers, perhaps it's a bit more of a level playing field. In B2C, the consumer is more king-like still because of all their regulatory protections, and we've kind of talked about that. But if you have a contract that has illegal terms, obviously they won't apply. So a vendor could go from a point of saying, I will have no liability to you if I do not perform. If that's illegal in a certain country to say that, you go from I have no liability to I have unlimited liability. Whereas if you adjusted it slightly, you'd be in much better shape. So, and that would even apply in England. If you had a contract that said I've got no liability to you at all under any circumstances, there's a danger a court would strike that out as being unlawful. So that's the kind of evolution we're seeing, is a move to a more sophisticated one-size-fits-all, but it's still very pro-vendor. And I think the view is, from all the analysis we've done, is the bigger vendors have more liberal terms than the smaller vendors, because the bigger vendors are more worried about this kind of thing happening. But the flip side is the economics of cloud depend on a much more standardized service. So you can't have a different contract with each of your customers, because that isn't cloud then. It's called a service agreement. It's just not cloud anymore. So how that tension gets addressed is interesting. So just looking at technology contracts, my view and everyone else's view who's looked at this is that the essential features remain exactly the same in the cloud as they ever did. There's a right to use, the license, which often gets spelt the American way. There's the meat of the deal, price, scope and service levels, what you're getting and how much. There's all the risk management stuff, privacy, security, access. An interesting one, not really sure of the background of everyone here, but most companies have requirements around audit in their contracts. I don't know if anyone even knows what their contracts say, but I bet they do. In the cloud, how do you audit the cloud? How do you go and see the data center on which your stuff's running? How do you get a server? Often, The starting point for these discussions is like that. Now, there's another thing that's evolved, is as technologists have got happier with this, risk managers have had to accept that if technology guys are happy that they can't go and audit a load of boxes in a room, make sure the lights are on in the old-fashioned way, they're going, all right, well, maybe we need to change the audit provisions. But that sort of audit thing is quite an interesting one, because some people are obliged to be able to audit, whether by company policy or by regulatory requirement. It's quite an interesting tension between the older world and the newer world. And then risk allocation, of course, limitation of liability, warranties, indemnities, all that stuff. And the future, termination and exit and renewal. If you put all your data into the cloud and you need to move on, how do you move on? If you put all your data into the cloud and your vendor doubles the price, what do you do? If you can't move on, what protection do you have? All that sort of stuff. And then all the boilerplate, including, of course, jurisdiction. Boilerplate is the back end of the contract that people rarely read. But some issues within that framework, which is always the same, have new importance, particularly around data. And this isn't a data talk, you'll be glad to hear, because I think too many data talks on cloud. And also who's providing your service at each level of the stack, which is a point I referred to earlier on about, it's all very well knowing who your software as a service provider is, but who's the platform provider? Who's the infrastructure provider? Do you care? Should you care? If you should, you need to find out. If you don't need to care, well, maybe you don't need to worry, provided your contract at the top of the stack is secure. So, the other thing is this stuff is often clicked through. So what is the contract? Traditional contracting, you get a big lever arch file of paper and people sign it. Open the champagne. Brilliant. In this world, you go onto a website, there's some terms of service, some T's and C's, there's a privacy policy, acceptable use policy. It's endless. What is in the contract? What are you obliged to live with? You need to think about that if you're buying it, and you need to think about that if you're selling it. Do you put it all in one neat place for people to pick apart? Or do you keep it in a nice user-friendly place, the acceptable use policy where it needs to be, the security policy where it needs to be? But if you click through all that, that's the contract. Actually identifying what the contract is tricky, and it may even be that the contract contradicts itself. So what takes precedence? And again, looking at jurisdiction, different bits of the contract may be under different jurisdictions, or maybe, and depending where it gets interpreted, different bits of the contract may take precedence over others. It can be a bit of a mess. So that is an issue to be aware of when contracting in the cloud. And then sort of looking at SLAs, which I think no talk about legals and cloud is complete without a look at SLAs. You know, you're going for lower price in the cloud. That's a primary driver. You're also going for innovation, getting closer to the market. So you're going for price and scope. You know, you're going for these two things. But of course, you've got the SLA. The likelihood is that the SLA may be excellent in the cloud, but the impact of breaching the SLA may be not much. Reputational damage for the vendor is often your best line of defense. So often an SLA is called a service level agreement, but is the reverse. It becomes a statement of non-obligation. It becomes a statement going, this is the service level agreement, we will give you 100% uptime. Unless we don't. Unless it's a maintenance window. Unless there's emergency maintenance. If we call emergency maintenance, 100% uptime doesn't apply. So 100% uptime complies only when they're up. So you've got 100% when you're up, but when we're down, we're not up, so therefore, how does that work? If you're buying this, be aware that's what you're buying. Be aware you're paying an appropriate price for it. And if they declare emergency maintenance the weekend before Christmas and you're a retailer, take the consequences. It's something people need to be aware of, because I think it's a great opportunity to get really, really cutting-edge services, and it's a great opportunity to reduce costs and still get those great cutting-edge services. But different vendors have different approaches to this. And as a business, you need to take an informed decision about it. So what's happening? Traditional technology contracts, dare I say it, can be a slightly long-winded process. There's an overemphasis on identifying every last risk and nailing them down and having huge fights about them and imposing vast suites of service levels with service credits and audit functions and monitoring functions. And, you know, do we need to do that? And the view in the cloud and the big cloud vendors that we deal with and advise is, no, we want to cut to the chase. We want to cut to the chase compliantly, and we want to cut to the chase without, you know, using our market power to abuse our customers, but we want to cut to the chase because we don't want to have a 6-month contract negotiation period. But I think there is a need to address the risks of many cloud contracts. There's a lack of certainty over the reliability point, the emergency maintenance type point I was making just now. There's a lack of visibility over service provision, particularly for regulated users. This is a point, if you're regulated, you need to know who's handling your data right down the stack. There's a lack of control over exit. There's a danger of lock-in or abandonment. And there's a web service provider called g.ho.st. Snappy title. It went down, stopped working, no one was using it, and they pulled their service that day. Gone. So, as I say, standard terms are evolving to reflect this, and even Google are negotiating. The only published contract is Google and the City of Los Angeles contract because it had to be published, and that clearly they negotiated away from their standard terms, which is quite interesting. If anyone from Google in the room, I apologise for bringing attention to this, but it is quite interesting, and it was a, you know, whether there have been problems with that, whether it's CSC's fault or Google's, who knows, or City of Los Angeles' fault, but it's been quite interesting that even in the cloud, people are willing to negotiate, but still give you the benefits of the cloud. So before I come on to sort of practical tips from what's been going on, what we've seen is going on, is there any sort of questions on the more general contracting issues?
It's actually a question, it's a comment. Cloud regulation, you should be aware of, because it just happened, the International Standards Organization has just set up, and I'm part of it, a new set of standards for cloud security. And it's Joint Technical Committee #1 and Subcommittee 27. In that regard, we only set up a week or so ago what's called the Mirror Panel for the UK, which is a group of standards. Anybody who wishes to take part in that, contact me through Professor Brownman via MSA. Because it's the whole drive of this actually started. And there are a series of major bodies which you will not be surprised at least in the States. Do not make failures.
And are you talking at the security session, which is, I believe, next?
I'm just here.
So someone is, and I think it's a professor, is talking at the security session. I'm sorry, I don't have my program in front of me, but absolutely, I think the use of standards is a way through this. The question is, there's two questions. You got the standard, but the standard's there. Then you've got a statement on the website, is we always aim to comply with the new standards. Is that contractually binding? I don't know. It may be, depends how it's put, but it may well not be, particularly if the contract says nothing we say anywhere else on our website applies. So what you need to look for is a contractual statement that says we shall comply with ISO standard on security, and that might well then mean that all of your security guys and your auditors and your regulators go, yeah, they're all right. And that's the way through this quagmire. It's a way to get to simplicity, provided the contract says it. And you can bet that most of these people don't say it because you've only just published the standard. So there'll be a time, there'll be a period, 5 minutes, perfect. I was a bit worried there.
With regard to that, there is a standard just about coming out, organised to our Australian colleagues called IT governance. I'm also involved in that, so they were also talking about it. Again, it may contact server.
And exactly. I mean, I think that's exactly the way it's going to evolve, is this sort of experts in communities setting standards with different stakeholders advising on it, the standards becoming the norm, and then suppliers saying, well, we'll comply with that standard. Again, the big vendors will say, we already do it. They'll change their terms and tomorrow probably saying, we comply with this. The smaller vendors will have more difficulties. But I think you're absolutely right. For people who are doing the contracting, it will become easier to tick risk management boxes by saying, look, our vendor complies with this standard, or all of these standards, or this suite of standards. And I think that's the way forward, a way forward. So just very quickly, On SLAs, just as we talked about this a bit, you know, you used to say you shall ensure the service is provided. Often these guys say we'll use reasonable endeavours to ensure the service is provided 24/7. What does that mean? It means they can take it down if there's a problem. But then, how about you will provide services consistent with good industry practice and all the standards, etc., which I would suggest good industry practice must mean complying with all the published standards, aims to achieve a target, but will provide you with notice before it gives maintenance. That's actually a weaker service level than the other three, but perhaps better from a business continuity and business certainty point of view. That's my one thought on service credits, service levels, and then lock in and exit. Contractually, this is what I think people need to do. They need to ensure they can walk away from the deal and ensure that when they do, they can take their data with them without being held to ransom financially. Most of these contracts won't say that. I don't think you need to. This doesn't add cost to a cloud deal. This is a side letter. You can just cover this off in an email almost. You know, we need the right to leave and we need the right to take our data. Tell us what it will cost now. Thank you. If you don't do that, you're in trouble, potentially, if something goes wrong. So best practice. And in this regard, I'd be really interested in other people's experiences, but this kind of summarises what we talked about, what I've talked about today, and various people from the floor have helpfully added to, is understand the layers behind your service. Do you at least know what they are, and does your contract reflect them? Who controls the infrastructure? Where is it controlled from? It's all very well having a brilliant software as a service, brilliant platform as a service. If the infrastructure is flaky, you're out of business. Where will data be stored and processed, which is the point you were making? You need to know. It needs to be in your contract. It needs to be controlled. And who can access it? Regulators, spooks, litigants. You know, different countries have different rules on how you get hold of information for litigation. Emails are flying around on servers. You can suddenly find all the stuff you thought was secret is no longer secret. What happens if someone in the supply chain goes out of business? How can you switch or insource? And have you seen the whole contract? This is the point about the acceptable use policy, the T's and C's, etc. And then think about your regulatory context and think about who your customers are. If you're in the B2C space, be careful, because you may have a contract with your customer that you can't back off with your supplier. And I think I'm to time. I'm getting a thumbs up from Hannah, so that's good. Does anyone else have any more comments or questions?
Just one. If you've got a recently PlayStation network was hacked,
Yeah.
somebody who was using Amazon VM, so they spun up an Amazon VM and they'd used that to hack into Sony. Now, I don't think at this stage Sony's going to sue Amazon to say what are you doing, but because I don't think Amazon are claiming that it was them hacking Sony. But there's something that I didn't see that you mentioned in there is know your customer. Sort of responsibilities on the intermediary.
Yeah. And I think that's what's usually covered in the acceptable use policy, is to know your customer. And I think there, and you need to make sure that your acceptable use policy that works great in Texas will work in Romania, France, Italy, because a policy, an acceptable use policy, is we can turn you off whenever we want. If we think you are doing something wrong, brilliant, exactly what you want in the situation you're talking about. If you try and do that to someone in another country where that's just not lawful and they're a consumer, and the likelihood is if they are doing something wrong, fine. But what if you shut them down because you think their pattern of activity looks like they're a hacker and they're not? Then you're in real trouble. And so it's that the acceptable use policy is how you address that. But again, you know, the acceptable use policy is another part of the contract you need to consider jurisdictionally, because that's where we started. To the Amazon point, I think if someone used Amazon nefariously and Amazon took them down as soon as they became aware of it, I think it's hard to see what Amazon did wrong. If Amazon could be shown to have negligently set their system up to allow people to use it nefariously, well, maybe, you know, Sony and Amazon and their various insurers will be in court in West Virginia for the next 10 years, which is obviously great for law firms with American offices. But the problem is, in the meantime, Sony's got a real problem about its network being down, and I think I think a smart hacker, it will probably come out that it was just a very smart hacker who consistent with good industry practice, you couldn't do anything about. And I am sure Amazon's terms give them lots of protection, and getting behind that protection will be hard, since it wasn't just an obvious negligent thing. Now, if it was, who knows? But that's a sort of, I think that takes us much more into the realms of a proper legal academic talk, rather than this sort of more, I'm told, business-focused talk that I'm told to give. But I take the point, absolutely, and I think they are interesting issues.